Well, good afternoon, everybody, and a very warm welcome to this latest in the series of webinars that we at Farrar's Building have been holding since lockdown started. Let me start by introducing myself for those of you that don't know me. My name is John McMillan. I'm a junior member here at Farrar's Building. I was called back in 2014. I have a mixed civil practice, but the bulk of my work, probably 70%, is personal injury work. And within that, I'd say about 75% or so is defendant work. So in today's webinar, we are going to be looking at quox and enforceable defendant costs orders in cases with no dishonesty, which I know is a snappy title, but hopefully it explains what I'm going to be talking about, which of course is the circumstances in which a defendant can enforce a costs order in a personal injury claim where there's no finding of fundamental dishonesty against the claimant. And I was moved to choose this topic for two reasons. First of all, as you may be aware, there's a recent Supreme Court decision which deals with some of these issues, Ho and Adelicon, which we'll come on to in due course. So that was the first reason. And the second reason was, I think it's fair to say that we as practitioners, since quox came in, have spent a lot of time thinking about and talking about fundamental dishonesty, perhaps at the expense of the how the wider quox regime works and is applied. And it just seemed to me that it might be a timely to just perhaps remind ourselves as to how it all operates. So what I intend to do this afternoon is talk for, I hope, no longer than about 45 minutes. Then at the end of that 45 minutes or so, there will be an opportunity for questions. I will take those, as I say, those questions at the end. You will see that there is a text box at the top of your screen if you hover your cursor for Q&A. So if you have any questions that come into your mind as we're going along, then please just type them in. But as I say, I will answer them at the end. And obviously, if you have any at the end, you can ask them then as well. The other point I should say is that you will see that I've got some slides. These slides will be circulated, as I understand it, tomorrow to you. So don't worry about trying to scribble stuff down. You'll get a copy of the slides. So let me just set out very quickly what I'm going to be talking about today. So you can see I'm going to be talking about the enforcement of defendants' cost orders against sums payable to the claimant, whether that's by way of a court award, a settlement, or costs. Cases involving multiple defendants, Part 20 claims, the position on strikeout, summary judgment, and discontinuance. Claims for the benefit of third parties such as credit hire companies and mixed claims. Now, before we go into those separate areas in detail, I thought it might be helpful just to remind ourselves of the context of quox. So I think if we take quox in isolation, particularly those of us who are primarily defendant practitioners, there can be a feeling sometimes, I think, that the whole quox regime is simply unfair. And so I think it does, as I say, have to be set within a context. And that context was helpfully set out by the Supreme Court in Ho and Adelicon. And what they said was, there always has been, and probably always will be, an inherent equality of arms between claimants and defendants in PI cases. This is because the defendants in most cases have the benefit of insurance, or in the case of the NHS, large resources, whereas claimants are in general ordinary members of the public, only a few of whom have the benefit of legal expenses insurance or other sources of funding of litigation. And so quox is an attempt to rebalance that inequality, and the whole regime has to be seen within that context. And of course, in fact, it's the latest attempt to rebalance that inequality. Some time ago, there used to be legal aid available to claimants. That, of course, was abolished in personal injury claims. Then we moved to a position where claimants could recover success fees and after the event insurance premiums. But the powers that be took the view that that tipped the balance too far in favor of claimants. And now we have the Quox regime. So it doesn't operate in isolation. It is important, I think, to remember that context. Let's then start by considering enforcement by a defendant of a cost order it obtains in its favour against monies that are payable to the claimant. And let's start by looking at what the rules say. So CPR 44.141 says, as you can see, orders for costs made against the claimant may be enforced without the permission of the court, but only to the extent that the aggregate amount in money terms of such orders does not exceed the aggregate amount in money terms of any orders for damages and interest made in favour of the claimant. Slightly clunky form of wording, but in other words, a defendant can enforce its cost orders up to the level that the claimant receives damages and interest under an order. And you'll see that I've added some emphasis to parts of that rule, because we'll see on the face of it that in order for enforcement to be available to a defendant, there needs to be an order. And you will see that whilst there's reference to damages and interest, there is no reference to the claimant's costs. And as we shall see, those matters are of some importance. So let's start by considering what happens if there isn't an order. So where there's a settlement, so where a claim has been issued, it hasn't gone to trial, parties have reached an agreement, money is paid to the claimant in damages, but not by way of an order. And this matter was considered, this issue was considered in Cartwright and Venduct Engineering by the Court of Appeal back in 2018. That case was a claim for noise-induced hearing loss, as is common in those types of claim. The claimant issued against a number of defendants. There were 6 defendants in that particular case. And the claimant agreed with 4th, 5th, and 6th defendants to accept £20,000 as a global settlement for damages, costs, and interest. And that was formalised by way of a Tomlin order. The claimant then discontinued his claims against D1, 2, and 3, and the 3rd defendant sought to enforce its costs against the claimant on the basis that the claimant had received £20,000, and it was therefore permitted to enforce its costs against the claimant on that basis under the rule that we just looked at a moment ago. And so 2 issues came before the Court of Appeal to be decided. The first was whether, in light of what we read in 44.14.1, whether the defendant could enforce against a sum of money paid by way of settlement rather than under a court order. And the second issue, which we'll return to later on, is whether one defendant could enforce a cost order in its favour against damages paid to the claimant by another defendant. And that first issue was of wider significance, because it didn't just apply to cases where there were multiple defendants. It would also have significance in cases where there was a single defendant and the defendant obtained a cost order in its favour, but the claim then subsequently settled. So, for example, a defendant might have got a cost order in an interim application before settlement, or it might be entitled to a cost order because the claimant had accepted a Part 36 offer late. And what the Court of Appeal said in Cartwright was first of all, in line with well-established authority, a Tomlin order wasn't an order of the court to pay damages and interest. The payment was pursuant to the schedule of the Tomlin order, and that was simply a record of an agreement between the claimant and the defendant. So there was no order for payment of damages or interest. As we've already seen, on the face of it, the court observed that 44 think that should be 14.1 rather than 16.1, forgive me, makes clear reference to damages and interest, but no reference, payable by a court order, and seemingly confined enforcement to sums paid under a court order, and didn't make any reference to settlement. And the natural reading of the rule was that settlement sums fell outside the scope of what could be enforced by a defendant under that rule. So that was the first point that the Court of Appeal made. And the second point that they made was that there were going to be practical difficulties with enforcement against a settlement if, as again on the face of the rules, enforcement was only possible against damages and interest. What was the court to do in circumstances where there was a global settlement inclusive of costs, as in Cartwright? How could it apportion damages and interest, which would be enforceable against, as compared to costs? And the obvious answer, there was simply no way to do that. And there was a further issue as well that the Court of Appeal struggled with, which was that the whole point of a Tomlin order is confidentiality. So how could it be that the court, in effect, was interrogating the terms of a Tomlin order? So the Court of Appeal reached the view, for the reasons that I've just given, that defendants aren't able to enforce cost orders in their favours against settlements. I think it's fair to say they reached that view with some reluctance, because there is an air of, I think, unfairness about it. I think it's fair to say, but the reasons that I've given for the Court of Appeal made it difficult, I think, to reach any other conclusion. And so that was obviously specifically within the context of a Tomlin order, but it does apply equally to any other type of settlement, formalized with or without a Tomlin order, because if you take a Part 36 offer, obviously there's no requirement for a court order. It therefore again falls outside the scope of what's said in 44.14.1. So in summary, enforcement against settlement payments are out. Let's then consider the position where a claimant brings a claim, it goes to trial, the claimant obtains judgment against a single defendant. The claimant obviously gets judgment for damages and is also likely to get its cost of the claim. But of course, there may be an order for the defendants, or in the defendant's favour somewhere along the line in an interim application, or it may be the defendant beats his own Part 36 offer and therefore is entitled to its costs post expiry of that offer, or indeed it may be, for example, that a claimant unsuccessfully appeals on the level of damages that he's been awarded, and therefore the defendant's entitled to an award in respect of that appeal. So all kinds of scenarios in which a defendant might have a cost order in its favour, notwithstanding that the claim has been successful. And what's clear and straightforward from the rule we looked at before is that the defendant is entitled to enforce up to the level of damages and interest that the claimant has been awarded. That's plain from 44.14.1. Now that's likely to cover the costs of an interim application, for example. The damages are likely to be higher than the cost of an interim application in most cases, but it may not cover the costs post expiry of a Part 36 offer, particularly in a low value fast track claim, or in a bigger claim where the Part 36 offer was made earlier, or indeed the costs of an appeal. So the rules, as we've seen, are clear that the defendant can, in effect, eat into the claimant's damages. But what about the claimant's costs? Can the defendant rather also eat into the claimant's costs as well as his damages? Well, this was the question that was recently considered by the Supreme Court in Ho and Dalycun. Now, in that case, Mr. Dalycun, the claimant, started a claim in the RTA protocol, and her claim subsequently settled by way of Part 36 offer for £30,000 plus costs. It's settled pre-allocation, and there was then a dispute between the parties as to whether or not the claimant was restricted to fast-track type fixed costs under CPR 45(3)A, or whether her costs fell to be assessed on the standard basis. There were two appeals on that point, but ultimately the defendant succeeded in persuading the Court of Appeal that the claimant was only entitled to fixed costs. So those fixed costs of the initial claim were, I think, somewhere in the region of £11,000 or £12,000. But in respect of the appeals over the basis of assessment of those costs, the defendant obtained a cost order in its favour that was worth somewhere in the region of £42,000. Now, because of Cartwright, because the £30,000 that the claimant received in damages was by way of settlement, the defendant couldn't use any of that to recover some of its £42,000 costs. But the question for the court was, well, what about the £11,000 or £12,000 in fixed costs that the claimant was entitled to for the initial part of the claim? Could that be taken into account? Obviously, the defendant wouldn't be able to recover the full £42,000, but could it, in effect, wipe out with that £42,000 the £11,000 or so that the claimant was entitled to for the costs of the initial claim? And what the Supreme Court said in Ho was that Quox is intended to be a complete code about what a defendant in a PI case can do with cost orders obtained against the claimant. In other words, if it doesn't say in the Quox rules at 44.13 to 44.16 that you can do it, or a defendant can do it, then the simple fact is that you can't do it. It concluded that an order for set-off is a form of enforcement. And as we've seen, because 44.14.1 only provides for enforcement up to the level of damages and interest and not costs, then the Quox regime didn't provide for offset against a claimant's costs. And so when calculating the amount that a defendant could enforce against under 44.14.1, as indeed the rule, I think, clearly sets out, the claimant's costs couldn't be taken into account. It was only the damages and interest, and so there was simply no way of the defendant enforcing, whether by set-off or any other means of enforcement. So this, as I say, a very recent case. The judgment was handed down only 2 or 3 weeks ago. And I think it's fair to say it's a significant case because the position had been different previously. An earlier case in the Court of Appeal, Howen MIB, the court had reached a rather different position. It had concluded that set-off was not a species of enforcement, and that whatever 44.14.1 said, and whatever the Quox regime generally said, the court still retained the general power of set-off under 44.12 in respect of Quox cases. But that now has obviously been overturned by or reversed by Ho. And the reality is that Ho is going to lead to some curious outcomes, as Ho, I think, itself demonstrates. You have that really strange position where the claimant in Ho is entitled to £30,000 of damages, £11,000 in costs, but the defendant has a cost order for £42,000 or so, and it's unable to enforce any of that, and still finds itself having to bear its own costs and then pay out additional monies in damages and costs to the claimant. So there are going to be curious outcomes in individual cases. But I think perhaps more significant is the damage that it does to the protection that a defendant can have by making a Part 36 offer. So let's start by considering what the implications are now for late accepted offers. So let's just use a worked example. Let's imagine claimant brings a claim. Defendant makes a Part 36 offer, let's say £100,000 in January. The matter is listed for trial in July, 6 months later. The claimant realizes that his case is now in some difficulty and accepts that £100,000 offer in July. Now, in the ordinary course of events, as is normal under Part 36 regime, of course, the defendant is now entitled to a cost order for that period from January to July, so post-expiry of the offer up until the actual date of acceptance. But of course, the defendant now can't do anything with that cost order at all. It can't enforce it against £100,000 damages because that's the effect of Cartwright, because it's a settlement and not a court order. And it can't use the claimant's costs pre-offer, so from before the January, that the claimant obviously will be entitled to his costs, can't use its cost order for January to July to reduce the claimant's cost. So in other words, that cost order that the defendant has in its favour for the period January to July is basically completely useless. And so it obviously provides the defendant with much less protection if it chooses to make a Part 36 offer. And it also provides much less of a risk to the claimant if he chooses not to accept the Part 36 offer, because he knows that he can always accept it down the line, and the defendant won't in any way be able to eat into either his damages or his costs at all. Now, of course, there's still some disadvantage to the claimant because he won't be able to recover his costs for the period January to July. But nevertheless, I think it's clear that the implications are really quite significant when it comes to the balance between the parties when using Part 36 offers. So that impact of her, it seems to me, is particularly stark when we're dealing with looking at late accepted offers. But there's also an implication for unaccepted offers where the defendant's post-expiry costs, so his costs after the expiry of the offer, are higher than C's damages. So again, let's just consider our example. Let's imagine the £100,000 offer is unaccepted, but let's imagine this time that it's not 6 months before trial, but it's a longer period, say 18 months. The case goes to trial. The claimant doesn't do anything like as well as he's hoping for whatever reason, only is awarded £20,000. The defendant is entitled to a cost order for that 18-month period post-expiry of the offer. But the reality is, in a large claim, that those costs are going to be much more than the £20,000. So he can enforce the cost up to that £20,000 and the claimant's damages is effectively wiped out. Before Ho, the defendant would probably assume they would also be able to eat into the claimant's costs that the claimant was entitled to prior to the expiry of the Part 36 offer. But now, of course, in light of Ho, the defendant can't. And so it's not quite as stark as in the scenario of a late accepted offer, but nevertheless, there are going to be scenarios, again, where the protection and the benefit of a Part 36 offer from the defendant, even if it goes on to beat its own up at trial, are simply not as potent as they were, certainly seemed to be prior to a few weeks ago. Let's move on to talk a little bit about enforcement with multiple defendants. So what we're talking about here is where a claimant obtains an order at trial, so judgment for damages against one or more defendants but is unsuccessful against other defendants. So this is, again, going back to Cartwright, you remember I said we were going to talk about the second issue a bit further on. In that case, you'll remember the claimant succeeded against 3 defendants, but not against the other. Obviously, in that case, the Court of Appeal decided that the successful defendants couldn't enforce against the settlement anyway, but it did consider whether, as a matter of principle, had it been a judgment rather than a settlement, whether one defendant could enforce against the claimant's damages, notwithstanding the fact that those damages had been paid by a different defendant. And what was argued in Cartwright by the claimant, unsurprisingly, was that a defendant could only enforce against damages that it was paying itself to the claimant, and not damages paid by another defendant. And what the Court of Appeal said in response to that, in some rare good news for defendants, was it rejected the argument of the claimant and said the Quox regime is designed to ensure that a claim does not incur a net liability as a result of his or her personal injury claim, that at worst he or she has broken even at the end of the action. But there is no reason why that regime should prevent B from recovering its costs out of the damages payable by A, B being one defendant and A being another defendant. So in other words, had that matter been concluded at trial, then the successful defendants, the third defendants, would have been able to enforce up to the level of damages that the claimant had been awarded by the court to be paid from the other defendants. So that was first bit of the logic of the Court of Appeal. It also went on to say that that was plainly in line with the wording of 14.1, and it also highlighted the need to discourage frivolous claims by claimants, because if that wasn't the correct outcome, then a claimant could in effect issue against as many defendants as it wished, almost with impunity. So, as I say, the outcome is that a successful defendant can recover against a claimant's damages from another defendant. Of course, a defendant will want to consider, in actual fact, at the end of the trial, whether it's more advantageous, in fact, to try and seek a cost order from another defendant. If the successful defendant's costs are higher than the claimant's damages, then it might be better to try and seek a sine or bullock order against one of the other defendants. But those considerations, I'm afraid, are outside the scope of this talk, but it's just something to bear in mind. And for claimants, any claimant practitioners listening, obviously need to be aware that Quox protection doesn't extend as far as a claimant in Cartwright wanted it to extend, and therefore claimants need to think carefully before issuing against multiple defendants. Right, so that was they're all the points about enforcement against sums payable to claimants. And I've just final slide on this point to kind of take stock of where we're at now. Well, I think interestingly, the Supreme Court said in Ho, we recognise that this conclusion may lead to results that at first blush look counterintuitive and unfair. No one has claimed that the Quox scheme is perfect. It is, however, the best solution so far, best solution that is to the imbalance that we talked about at the beginning. And I think, as I already said, in Cartwright, I think it was clear that the Court of Appeal wasn't entirely happy with having to reach a decision it reached. And both Cartwright and Ho said that these were matters that the Civil Procedure Rules Committee might want to consider, or if any changes were going to be made, it was going to have to come from the Rules Committee. But certainly, as far as I'm aware, there's no indication that any changes are on their way. And as I say, my view is that Ho has now changed the balance quite significantly between claimants and defendants, particularly within the context of Part 36 offers. So moving away then from enforcement against sums payable to claimants and just considering other situations more generally, let's just consider contribution and indemnity claims. So what we're talking about here, of course, is where a claimant brings a claim against the defendant and a defendant brings in a third party for a contribution and/or indemnity. And the reason why this is an issue that is initially at least caused some argument is if you look at the CPR 4413, what it says is this section applies to proceedings which include a claim for damages for personal injuries. In this section, claimant means a person bringing a claim to which this section applies or an estate on behalf of which such a claim is brought, and includes a person making a counterclaim or an additional claim. And of course, if this section applies, then the claimant is entitled to quox. Now, just looking at that at face value, an additional claim includes a contribution or indemnity claim. So somebody bringing a contribution or indemnity claim is a claimant for the purpose of the quox regime. And the quox applies to proceedings, which include a claim for damages for PI. And of course, within the whole proceedings, the claimant is bringing a claim for personal injury. And so what was argued in the case of wagonr was that meant that the defendant who was claiming a contribution from a third party was protected by quox if that additional claim was unsuccessful. So just very briefly, the facts of that case were that a claimant was injured skiing on holiday. She brought a claim against the tour operator under the package travel regs. The tour operator, the defendant, then brought in the ski instructor as a third party for a contribution and/or an indemnity. All the claims failed. So the claim failed against the defendant. The claimant's claim failed against the defendant, and it followed from that there was no contribution or indemnity from the third party to the defendant. In the first instance, the judge correctly, of course, held that the claimant was protected by quox, but also held that the effect of the rules were that the defendant was protected by quox in its claim against the ski instructor, and the ski instructor therefore couldn't recover his or her costs against the tour operator. It went up to the Court of Appeal, and we can see that what the Court of Appeal said was, in my judgment, the proper meaning of the word proceedings in 4413 has to be defined primarily from the rules on quox themselves. The whole thrust of 4413 to 4416 is that they concern claimants who are themselves making a claim for damages for personal injuries. I think the word proceedings in 4413 was used because the quox regime is intended to catch claims for damages for personal injuries where other claims are made in addition by the same claimant. And the effect of that conclusion, of course, is that if you're not bringing a claim for personal injuries, then you're not brought within the quox regime. And therefore, if you're a defendant bringing a claim for a contribution and/or an indemnity, you don't have any quox protection, which I think plainly must be right. I don't think there's any intention that defendants in those circumstances were intended to have any cost protection under the quox regime. Counterclaims, talk again briefly about counterclaims. We're considering here, the claimant brings a claim against a defendant. The defendant then counterclaims for personal injury. The claimant is successful, the defendant in their counterclaim is unsuccessful. As a counterclaimant, they are a claimant for the purposes of the quox regime. The question is, are they then insulated from any liability for costs to the claimant at all? I.e., does quox protect them for the whole proceeding, not just in bringing their claim, but also in defending the initial claim from the claimant? Well, in the first case where this was considered, His Honour Judge Freeman up in Newcastle, in the case of Ketchian and McEwen, concluded that the defendant counterclaimant in that scenario was protected, and therefore, even though the claimant won in that case, the defendant didn't have to pay any cost at all to the claimant because the defendant had brought a PI counterclaim. It came, or the issue was again considered, again at circuit judge level, so of course none of these are binding, but by Her Honour Judge Venn in Waring and McDonnell, and Sutcliffe and Ali by His Honour Judge Gargan. Both of them were referred to Ketchian. Both of them declined to follow Ketchian. Both took the view that this wasn't the intention of Quox to protect defendants who had actually lost against a claimant. And I think what helpfully illustrates the point is an example that was given by His Honour Judge Gargan. So imagine a motorcyclist who suffers catastrophic injuries in a collision with a car. Claimant motorcyclist brings a claim for very significant personal injuries. Imagine then the driver of the car brings a counterclaim for a modest whiplash injury. His Honour Judge Gargan said it couldn't possibly be the case that simply because the defendant had brought this counterclaim for modest personal injury, and assuming, of course, that the defendant had lost, the defendant then was protected from any cost liability at all against the claimant. That the claimant wouldn't be able to recover any of his costs for bringing this very significant personal injury claim. So I think that illustrates very well that, with the greatest respect to His Honour Judge Freeman, that's not, I don't think, what Quox was intended to bring about. There's no definitive case dealing with that point, nothing that's binding on any courts, but I think it's very unlikely that Ketchian is going to be followed by any judge now, although I do still see people in court from time to time trying to raise that argument. I'm conscious of the time, predictably going on longer than I had anticipated. I'll try to speed up a little bit. Let's move on to cases in Farrar involving strikeout position in respect of Quox once a claim has been struck out. Starts off not with specific Quox provisions, but rather just the general grounds for strikeout contained in Part 3 of the rules. I'm sure most of you are familiar with these grounds, but just to remind ourselves, 3.42, the court may strike out a statement of case if it appears to the court that the statement of case discloses no reasonable grounds for bringing or defending the claim, that the statement of case is an abuse of the court's process or is otherwise likely to obstruct the just disposal of the proceedings, or that there has been a failure to comply with a rule, practice, direction, or court order. Let's then compare what the rules in the Quox section say about the disapplication of Quox following strikeouts. It says orders for costs may be made against the claimant may be enforced to the full extent of such orders without the permission of the court, where the proceedings have been struck out on the grounds that the claimant has disclosed no reasonable grounds for bringing the proceedings are an abuse of the court's process, or the conduct of the claimant or a person acting on the claimant's behalf and with the claimant's knowledge of such conduct is likely to obstruct the just disposal of the proceedings. And the eagle-eyed amongst you will have no doubt observed that the ground for strikeout in 3.42, the failure to comply with rules, practice, directions, or court orders, isn't included in the Quox provisions as a basis of strikeout that leads to the disapplication of Quox. So the obvious implication of that is that Quox is not automatically disapplied on strikeout. It will only, certainly on the face of it, be disapplied if the claim is struck out for the particular reasons that are listed at 44.15, and specifically, seemingly not for the failure to comply with rules, practice, directions, or orders. Having said that, I have noticed, certainly at district judge level, a willingness of some judges to treat Rule 44.15.1c. So that's the provision in the quox section that this applies quox, so where the conduct of the claimant is likely to obstruct the just disposal of the proceedings, to use that as something of a catch-all to disapply quox when, in fact, in reality, it doesn't particularly neatly fit in within that description. So to give you an example, I not too long ago appeared in a fast-track trial. The claimant didn't turn up. It was a liability dispute. There was no allegation of dishonesty. So in reality, the best that we as defendants could hope to do was get the claim dismissed and get a cost order that would effectively be meaningless because the claimant would be protected by quox. I applied to strike out the claim, and I sought to argue that quox ought to be disapplied on the basis that the claimant's conduct was likely to obstruct the just disposal of the proceedings. And the judge accepted that and disapplied quox. As I say, I think using it something of a catch-all, because in reality it's difficult to see how the non-appearance of the claimant obstructed the just disposal of the case, because we had got everything that we were ever likely to get. So, as I say, there are some judges who are willing to treat that as something of a catch-all. Equally, in similar situations, I've made similar applications, and the judges said, well, the facts that simply don't fit within what you're suggesting. It does fit within. So that's strikeout. Let's move on to look at the position on summary judgment and discontinuance. This is thankfully straightforward. In the absence of a finding of fundamental dishonesty, the fact of the matter is that the summary judgment and discontinuance don't lead to the disapplication of quox. The claimant has quox protection following summary judgment and discontinuance. Of course, following discontinuance, the defendant can still apply for a finding of fundamental dishonesty and disapply quox in that way, but that is the only way. It's difficult to see how there could be a finding of fundamental dishonesty along with summary judgment, to be perfectly honest. So if a defendant is making an application for summary judgment, then I would always suggest making an application for strikeout on the basis that the particulars of claim disclose no reasonable grounds for bringing the claim in the alternative, because if you can persuade a judge that that applies and it's not too far away from summary judgment, then, as we've already seen, that is a basis on which quox can be disapplied. Right, moving on to the last section of the webinar, which is claims for the benefit of a third party and mixed claims. These types of claims are dealt with at 44.16.2, which says orders for costs made against the claimant may be enforced up to the full extent of such orders with the permission of the court, and to the extent that it considers just, where the proceedings include a claim which is made for the financial benefit of a person other than the claimant. So that's the benefit of a third party. And then at little b, a claim is made for the benefit of the claimant other than a claim to which this section applies, which is the mixed claims. And in respect of the claim for the benefit of a third party, we see a paragraph 3 there, where paragraph 2a applies. The court may, subject to Rule 46, to make an order for costs against the person other than the claimant for whose financial benefit the whole or part of the claim was made. In other words, as well as getting an order against the claimant, you can get an order against the third party who is the true beneficiary of the claim. So let's look a little bit more closely at claims for the benefit of a third party. And sorry to be repetitious, but just let's look again a little bit more closely at 44.16.2a. So the proceedings include a claim which is made for the financial benefit of a person other than a claimant, or dependent within the meaning of a Section 1.3 of the Fatal Accidents Act 1976, obviously a fatals claim. Then it says, other than a claim in respect of the gratuitous provision of care, earnings paid by an employer, or medical expenses. So obviously what we're talking about there in brackets is care and assistance. So claim for care and assistance is for the benefit of the person who is actually providing the care. Medical expenses might, for example, be for the benefit of the physio therapy provider. And what it's making clear is that those types of claim, which are part and parcel of a personal injury claim, are not covered by 44.16.2a. And in fact, it gives examples of the types of claim it's referring to in the practice direction. And those types of claim specified are credit hire claims and subrogated claims. So in other words, it's a kind of, I suppose, a step of removal from what would be part and parcel of a personal injury claim. So important to note, as I'm sure you will have done already, that where the claim is for the benefit of the third party, permission can be sought to enforce against the claimant, him or herself, or in fact the third party who is the true beneficiary of the claim. And what was said in Me and Jones, which was a case that dealt with a credit hire company, was said it will usually be the case that it is a relevant non-party who has sought a financial benefit who will be first in line. And I think that obviously makes sense, doesn't it? Because the whole point is that the claimant isn't the true beneficiary. So why would it be that the cost order would be enforceable against them rather than the person who is truly benefiting from litigation? But of course, in any event, from the point of view of the defendant, the reality is that a credit hire company or an insurer bringing a subrogated claim is likely to have deeper pockets than a claimant, and is likely to be a more attractive proposition in terms of seeking recovery of costs. Now, in terms of the procedure, third-party cost orders generally are dealt with at 46.2 in the CPR. And it's important to note that whilst 44.16.2 makes reference to third-party cost orders within the context of quoks, it doesn't actually give the court any new power or any new discretion. It simply highlights the fact that the court has a power to make a third-party cost order, which is always had under the rules and has done for some time. And the exercise of that discretion, therefore, isn't in any way different from the usual consideration that the court will have when considering whether a third-party cost order ought to be made. And the leading case on that general discretion is Deutsche Bank and Sebastian Holdings. And we can see what the Court of Appeal said in that case was the only immutable principle is that the discretion must be exercised justly. And when an order for costs is sought against a third party, the critical factor in each case is the nature and degree of his connection with the proceedings. So very wide discretion, but what's going to be fundamental to that, or to the exercise of that discretion, is how closely involved that third party was. So if you have a credit hire company that is funding the proceedings in all likelihood, is controlling the proceedings in all likelihood, and stands to benefit from the proceedings, then it seems to me that a defendant is going to have a strong argument that the court ought to make a third-party costs order. But the discretion is wide, not just as to whether or not an order ought to be made in the first place, but also the extent of that order. So as an example, Me and Jones, which was a case I mentioned whilst we were looking at the previous slide, was a High Court case in which the court was hearing an appeal of a decision to make a third-party cost order against a credit hire company. What had been held at first instance and indeed upheld on appeal was that the credit hire company ought to pay 60% of the defendant's costs. That was in circumstances where the claimant's claims for personal injury had been unsuccessful, relatively modest claim, a whiplash type injury, £3,000 or £4,000 maybe, and there'd been a credit hire claim for somewhere in the region of £25,000, which had also been entirely unsuccessful. And finally, moving on to mixed claims, which again, sorry for being repetitious, but just to remind ourselves what we saw in the rules before. This is a claim that is made for the benefit of the claimant other than a claim to which this section applies. In other words, it's part personal injury claim and part claim for damages unrelated to personal injury. And what the High Court made clear in the case of Jeffries and the Commissioner of the Metropolis is it doesn't matter if the two separate parts of the claim arise from the same cause of action. Indeed, the reality is that in most cases, they will arise from the same cause of action. The question is whether the claims are for different types of loss. And again, it was stressed that the personal injury included consequential loss of earnings, care assistance, etc., and not just pain, suffering, and loss of amenity. So, to give you an easy example, I'm involved in a case at the moment where there is a claim for defective premises. There is a very minor personal injury claim. It's said that the defect caused the claimant to have an allergic reaction to some mold, but the claim encompasses a much wider claim in respect of defects to the property for damages that are entirely unrelated to personal injury, so damages to either put right the property or for its diminution in value, which I think highlights quite nicely the types of claims that are being considered. So property damage generally is obviously not something that is part of a personal injury claim, in the sense it doesn't have any direct connection with the injury, it doesn't flow from the injury. But in the case of Commissioner of the Police for Metropolis and Brown, the Court of Appeal did say that in the context of a road traffic accident, where a claimant's claiming for injuries resulting from the road traffic accident, but also property damage to their vehicle, the likelihood is that a court is going to consider the claim for the damage to the vehicle to be part of a personal injury claim in the round. Of course, that might be slightly different if, for example, you've got a very low value personal injury claim, a couple of £1,000s, and then at the same time you have a claim for a supercar that's been written off that's for tens or hundreds of thousands of pounds. But in the general course of things, as I say, vehicle damage in an RTA is unlikely to be considered a mixed claim. Again, as with cost orders against the third party, the discretion is very wide in respect of a mixed claim. The court has discretion whether or not to make a cost order again, and if it does choose to exercise that discretion, how much or what percentage of the cost to order. And of course, key considerations are likely to be how much of the claim is PI and how much of it is non-PI, I suppose, both in monetary terms, i.e. the amount of damages claimed, and also how much lawyer time is likely to have been spent on those respective parts of the claim. So you may be pleased to hear that that is the end of the talk parts of the webinar. I'm sorry I've gone a little bit longer than I anticipated. I can see that I've got questions, which I will do my best to answer. So the first one says, why can it not be offset against the damages again? And I assume that this goes back to when I was talking about Ho, where, if we remember, Ho had agreed a settlement of £30,000. The Supreme Court held that defendant's costs could be offset against the costs. The reason why it couldn't be offset against the damages was because it wasn't a court order for damages. You may remember 4414 once specifies that only orders for damages and interest, orders being the crucial point, and the Cartwright said it can't be offset against a settlement. If parties cannot agree a consent order on late acceptance of Part 36 offers, defendants will undoubtedly not pay the damages within 14 days. Claimants will have to seek judgment, and then the defendant can enforce, which is, thank you, that's from John Pennington, and as he's suggesting, I think, a rather clever way of trying to get around the unenforceability of a defendant's costs following the late acceptance of a Part 36 offer. It's an interesting point, John. I hadn't thought of that. I haven't quite thought that through. You may well have a point. It's certainly something to look at. Obviously, the dust is still settling on her, and people will be no doubt thinking of the various different ways in which they can seek to get around it. I'm not sure you need a consent order following Part 36 offer. I think I think it's implied within Part 36 acceptance that is paid within a specified period of time. But you are, of course, right to say that if it's not paid, you can seek judgment. William Stobart asks, is Part 3615 a sensible way around the limitations of Cartwright? Which may be a good question, but I'm afraid to say off the top of my head, I don't know what Part 3615 says. So I'm happy to have a look and get back to you, but I'm afraid my knowledge of the rules isn't photographic, so I'm not quite sure what 3615 says, but I will certainly have a look. Also from William, on a related note, what is the effect if the claimant if C is the party making an offer to settle to a sole defendant where defendants are sued jointly, do other defendants still need to consent? I can't see why they wouldn't still need to consent. There's nothing, as far as I'm aware, that has changed in her or in anything else that changes that position. So certainly my understanding is, off the top of my head, that nothing has changed in that regard. Matthew Griffiths, hi Matthew, thank you for your question. Says, when seeking a third-party costs order, when should you put that party on notice that you are going to do it? Do you wait until after the costs order has been made against the claimant before applying to add the non-party to proceedings? That's an interesting question. So you're right to say, of course, that the third party has to be brought into the proceedings. They have to have notice. They have to have the option of attending a hearing to make arguments as to why they ought not to have to pay a third-party costs order. You can make an oral application at the end of trial to bring in the third party. I'd say my success at doing that is not particularly high. I think judges are a bit reluctant to do it orally. I've heard it argued that the court doesn't have jurisdiction without putting the third party on notice. It's going to be joined into the proceeding. So you can make an application off the cuff at the end of trial. I suspect it's probably better in actual fact to do it in writing by way of an application notice after the proceedings. And the second part, do you wait until after the cost order has been made against the claimant before applying to add the non-party to the proceedings? Again, I think you have to be a bit careful, because if you defendant, you seek a cost order against the claimant in at the end of the trial, then I think there is a danger the court might take the view that the costs have already been dealt with. So I think if I were in that position, I would be asking for a recital that the defendant was intending to make an application to join the third party and ask for costs to be reserved. And then a question from an anonymous attendee. If a defendant makes a Part 36 offer which a claimant accepts out of time, then on the face of it, there is no order which entitles the defendant to pay Part 36 cost per cartwright. Can the defendant at this point protect itself in any way? For example, could they apply for an order that they are liable for damages subject to set off against the post-Part 36 costs that they are entitled to recover? That would appear to create an order which can then be enforced to the level of damage and mean that damages don't need to be released, creating a risk of an unsatisfied judgment. So if what I think you're asking is, in effect, you settle a case, and then to get around cartwrights, you make an application to the court for an order that the sums agreed under the Part 36 offer be paid. I suppose it's a slightly different way of trying to get around the effect of hoe and cartwright, but not dissimilar to that first question, or first or second question that I dealt with. I'm struggling, if I'm honest, I mean, I can obviously see the sense in it, why you would ask. Off the top of my head, I suspect court might be reluctant to start getting involved in making orders under those circumstances, to be perfectly honest. Obviously, there's benefits to the court and the court resources in matters settling by way of Part 36, and I think the last thing that they would want to encourage is parties then using court time and resources in the way that's been described. So, look, I suspect as the dust settles on hoe, that defendants inevitably will use various ruses to try and get around the effect of that case, and indeed cartwright, as best they can. How successful they will be, we will have to see. I think my instinct is that I'm doubtful, but I don't know. I think if this whole area is just rereading the cases again, what this whole area is reminded me is that lawyers will argue about pretty much anything. I mean, I think the rule is so clear in 44.14.1 that enforcement is only possible against damages and interest, that it's really quite surprising that there were so many cases going to the higher courts dealing with whether there could be offset where there was a settlement, or offset against costs and so on. But there we go. We'll see what happens. Gus P, thank you, Gus, for your question. Will a Calder Bank offer trump quox, i.e. acceptance requires court order, no requirement for Tomlin? So I suppose what you are asking is, if you as a defendant settle a matter not using Part 36, not using a Tomlin order, but can somehow persuade a claimant solicitor to agree a consent order, not Tomlin orders, but a normal consent order, that under which the court orders the defendant to pay damages, then I imagine you're asking, does that therefore mean there's a court order and that the defendant's costs can be offset against those damages? If that's your question, and I hope I've understood it correctly, then I think that must be right. But it's going to be a pretty foolish claimant solicitor who agrees to a consent order in those terms, although, you know, it might be worth a go. Another question, just to confirm, the only way either the claimant or defendant can enforce costs of beating their own Part 36 offer is dependent on the result after trial. So, I mean, if claimants can always enforce their cost orders in their favours, whether it's Part 36 or not. Quox doesn't give, sadly, any protection to defendants, with my defendant hat off for a moment. So whether a defendant can enforce its cost of beating its own Part 36 offer, will that depend on the result of trial? Well, yes, it will, in the sense that it will only be able to enforce any costs to which it is entitled up to the level that the claimant has been awarded damages. So if the claimant has been awarded nothing, if the claimant has lost his case entirely, then the defendant can't enforce anything. If the claimant, say, has been awarded £10,000 and the defendant has a cost bill of £20,000 to which it's entitled to an order, or for which it's entitled to an order, then it will be able to enforce that those costs up to the £10,000 of damages. So I hope that answers your question. Question from Mary Edith. Thank you, Mary. Does an order made by the court on approval of an infant settlement count as an order for the purposes of 4414? Well, that goes back to the I think I was just talking about a moment ago, where there's a consent order. I mean, effectively a court order following an infant approval is effectively an order for damages by consent, isn't it? I mean, I assume that would count as an order from the court. That was certainly my assumption when I was answering Gus's question a few moments ago. There isn't any authority on it as far as I'm aware, but as a matter of logic, it's an order made by the court, and there is an order for damages to be paid to the claimant, albeit it may be via the court funds or office or whatever. So yes, I would imagine that it would count as a court order, and therefore you can get it within the scope of 4414. I hope that answers those questions, those of you that have asked. Thank you very much for asking them, rather. Some interesting issues raised. You have on there my email address. If anything comes to your mind after today and you want to get in touch about this or anything else, then please do feel free to get in touch. Otherwise, it just leaves me to thank you very much for joining us today. Have a very pleasant evening, and hope to see you all sometime soon. All the best. Thank you.